next matter to come before the court this morning is HSBC Bank versus Evis Brinson et al. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal if you're the appellant, and plan to reserve any time for rebuttal if you let me know when we get started. I'm keeping the clock, which you can also see is on the wall over there. The arguments are being recorded. Please remain behind the podium and keep your voice up. Do not use the names of children or minors or victims. I don't think that's a problem in this case, but we'd like to make that advisement. The judges have read your briefs, and we are ready to see when you are.
Thank you, Your Honors. My name is Colin Skinner. I represent Evis and Brinson and the defendants and the appellants in this case. I'm sure that you had a headache reading the brief, which is rather long. This case involves residential mortgage foreclosure, and according to HSBC, the plaintiff, there was an originator on this loan, Quicken Loans, and then there's just two. So you have to think, how complicated can that be? There should be an assignment from Quicken to HSBC, and there should be an endorsement on the note from Quicken to HSBC. But unfortunately, that's not what's presented in this case. In fact, this is the second time these parties have been before this court. It's a different panel, but in the original case, the HSBC prevailed below. We came up on appeal in this court. We looked at the assignments that were presented. First, there was a note that showed that it was originated in MERS by Quicken, and Quicken endorsed the note to something called IndyMac Bank, and then IndyMac Bank created a blank endorsement. The mortgage assignments go from Quicken Loan as the originator to HSBC, big, long, complicated name. I call it HSBC 1 because it's not the same as the plaintiff. And then there is a second assignment from HSBC 1 to the plaintiff. In a brief, I referred that to HSB 2. So instead of what you should see in a case like this, you've got this complicated chain of documents. Now, this court remanded it to the trial court. The trial court said, well, you didn't have standing when you filed the case, so I'm going to dismiss it without prejudice. HSBC then brought this case, and it's the same chain of title. There's no dispute that. The exact same documents, there's modifications, the same assignments, same endorsements, everything's the same. What we have is an expanded summary judgment affidavit. They submitted it, and the court ruled in their favor. The problem with it is this court said, in its earlier opinion, it said, why do the endorsements on this note not track with the assignments? That doesn't make sense. That's why the court ruled that they didn't meet their burden. In this case, they said, well, I'll explain those discrepancies. Explanation one is the note was endorsed to IndyMac because it was our servicer. That doesn't make sense because that's not what servicers do. Their other explanation, the discrepancy, it says, we've always had the note. It's only one entity. We've always had the note since 2007, right after it was originated, and they presented a tracking from 2007. It went to Deutsche Bank, not HSBC. It went to Deutsche Bank, and then in 2014, this tracking says it went to Aquin, a servicer that doesn't appear on the note, and then it tracked to Counsel. That can't be true. For one thing, MERS, that nightmare mortgage electronic registration system that caused the last banking collapse, as I recall, was part of this loan. It was the nominee for Quicken when it was originated. It stayed in MERS. MERS signed a modification in 2010. It signed the first assignment in 2010. So from 2007 to 2010, Deutsche Bank was holding this note for MERS, not simply HSBC. The other issue with that is the chain of title also doesn't show several transfers, because there was an earlier case, apparently in my appellate brief, I might have cited it wrong, but it's all in the record. There was an earlier case, 2010 to 2010, counsel said, I have this note, and here's a true and accurate copy. It doesn't have any IndyMac endorsement.
That was a note for this property or a separate property?
This property. I apologize. There was a citation error. If you look, it's actually, I cited it quite directly. There's a request for admissions where they admitted the authenticity of the document from the 2010 case. In this case, it was filed February 20th, 2021.
And even though the 2010 case dealt with a separate property, the note in this case was included discovery in that separate property?
No, the 2010 case dealt with the exact same mortgage, the exact same property. Apparently, I must have put a wrong case number down. We talked about Scrivener's errors in the last one. That's just in the appellate brief. If you go to the record, it's quite clear. It's the same mortgage. It's the same note. It was filed.
What was the result of the 2010 case? Was there a foreclosure in that case?
Yes. Well, it was resolved by modification. It's a foreclosure case. It was resolved by modification, which, by the way, as I recall, was signed by IndyMac as lender. And Quicken Loans signed it as a nominee. There's two modifications, none of them mention HSBC at all. So what we don't know is, when did IndyMac get it back? For one thing, their chain of title for this custodian is incomplete because there's transfers that aren't reflected.
What did the affidavit say when IndyMac became holder of the note, as I understand was their role in this case?
They claim in the foreclosure or in their MSJ affidavit that IndyMac was a servicer. And we've gone round about this in the briefs. A servicer, and I cited the Anderson case from the Supreme Court, has a contractual relationship with the lender. It's essentially a bookkeeper. It collects money, it records it, it doesn't own the loan, it doesn't own the note, it doesn't enforce the note, it doesn't have any privity of contract with the borrower. That's the Supreme Court taught. That's what a servicer does. So you would never endorse a note to a servicer.
Does the affidavit in this case say the note was endorsed to IndyMac?
Yes.
I just want to make sure that clear it says that's what occurred. You would dispute why it would occur, but the affidavit said it occurred and went to IndyMac.
Yeah, I would agree with that. They said it was endorsed to IndyMac because it was a servicer. That doesn't make sense.
Is there anything statutorily or case law-wise that says a server cannot be a holder?
Well, it's the role, I'm relying on case law in this case, but it's the role of the servicer because it doesn't have privity of contract with the borrower. It doesn't own the loan. It's a bookkeeper. That's essentially what the servicer does. There are three different servicers in this record. There's PHH, there's Aquin, and allegedly there's IndyMac. None of them appear on the note to IndyMac. And I think that sets up a dilemma because to explain why IndyMac's there, they say, well, it's just a servicer. Don't worry about it. But if it was just a servicer and it didn't have the right to enforce the note, it couldn't create a valid endorsement back to Quicken. And I think a lot of this comes down to essentially the court made one essential sentence where they said, I'm going to ignore all this noise about the wrong assignments and things. I'm going to rule that since they have the note, it's immaterial how they became holder of the note. That's an incorrect statement as a matter of law. For one thing, holder is a conclusion that hasn't been established. Holder is a legal status. You can be a transferee, you can be a possessor. Everyone that gets their hands on a note doesn't become a holder.
Well, she calls it bearer paper, right, at that point?
She does call it bearer paper at that point, but that presupposes that IndyMac was a holder in due course. You have to be a holder in due course to create one behind you, and we've cited a case law to that effect.
And the Anderson case, I think that's the case you cite that you're referring to regarding whether IndyMac can be a holder?
No. Well, the different case, it was the Ohio Savings case and the Heron case, where it talks about the fact that if you've got an invalid endorsement in your chain of title, it's just like having an invalid assignment. If you've got a bad endorsement, then the subsequent people that took from that, that took the note, aren't holders in due course because there's breaking the chain of title. There's another, just a little bit of an aside. There's these two assignments between HSBC and HSBC2. And my issue with that is that they say, well, it's the same entity, we were just fixing the name. So what they're really saying is that Quicken assigned this mortgage to an entity that didn't exist, and then this non-existent entity assigned it to the plaintiff. That's not how you fix a problem with a change. You've got a back conveyance, you go back to the original assignor and you say, do a corrective assignment to me so you have the name right. That's how you're supposed to fix it. Maybe you could try an affidavit of fact, maybe you could try a certificate of merger, but you can't have nothing assign this to somebody, fix your chain of title. It's just an incorrect way to do it as a matter of property law. And that would bring me to the next assignment of error, in my opinion. You ask yourself, well, we've got all these weird discrepancies. How is there no question of material fact in it? The affidavit contradicts itself. It says things that don't make a lot of sense. And I don't know what happened to that old
How
song.
did it contradict itself specifically?
And counsel, be aware that we didn't talk about reserving any time for rebuttal, and I want Judge Stevenson's question answered, obviously. But you're right at 5 minutes, so.
All right, I will conclude after this. Your question was, how
How did the affidavit contradict itself?
how the affidavit contradict itself? Well, in the ways that I've been discussing. It says that it gives a timeline with a custodian that can't make any sense. It gives this indication of servicer role that doesn't make any sense. Maybe not contradicts itself, it contradicts what the law says should be here before us and what should not.
It's not internally inconsistent, it's just you don't agree that it fits under the law that these folks can be a server, therefore it's.
That's correct.
There's a material fact.
That's correct. And I think if you're gonna do inferences in favor of the non-moving party, that these sorts of problems should be at least ironed out on a full record. I didn't get to the other assignments of appeal, but I think those are straightforward. Thank you very much.
May it please the court, your honors, I'm Robert Dawson, I represent HSBC Bank. And I'll stick with the HSBC too, because it is a little bit to go through. This case is opposing counsel stated, it was previously appealed in a prior foreclosure. At that time, this court said that there wasn't sufficient information to deal with all of the issues of the assignment, et cetera, that had not been included in the affidavit. Therefore, the court determined that there was no standing because it wasn't going to infer what the argument should have been by HSBC at that time. It sent it back. The court dismissed without prejudice. The appellant wants to argue that for some reason that should preclude us from filing another foreclosure action because of the standing, the dismissal without prejudice. And case law is clear that dismissal without prejudice does not prevent a suit thereafter. I believe in the reply brief, the appellant asked that the court make an exception, which there's no basis for making an exception when their standing is an issue. There is case law, Bayview Loan Servicing versus Likely. That's 2017 Ohio 7693, which states the dismissal in the early proceedings of a foreclosure action for standing is not an adjudication on the merits. So that is not an issue. The trial court laid out that the new affidavit does clarify the chain of title. It specifically sets forth where the note went, what happened with the mortgage. All that's in the affidavit, which is found at its document number, document 107 of the docket. And it clearly lays out what happened with this note. The note was originated in 2006. It's Quicken into Quicken Loans. Quicken Loans, then it went for filing the mortgage as a standard. The mortgage is a separate document, the note is a separate document, they're not one and the same. I believe the appellant mistakenly argued that MERS somehow is the holder of the note. MERS is not on the note. It was the holder of the mortgage as nominee for Quicken, and Quicken's assigns. And as standard practice, MERS will hold that mortgage until such time as it might be needed. And then if these things are transferred, the note is transferred, they will then assign it back to the current owner of the note so that they can bring this foreclosure. It's exactly what happened here in 2010. The loan was in default, and they moved to assign the mortgage into HSBC, the current holder. They did that via the assignment, which was in 2010, February of 2010. That assignment incorrectly stated that it's assignment of the mortgage and the note. MERS didn't hold the note. MERS didn't have the power to transfer the note. They were just, I believe the scrivener that did that was simply trying to state that the note is held by HSBC, and so they were noting that in the assignment. But they didn't have the power to sign the note. They didn't possess the note. They never were in the chain of title of the note. The chain of title of the note in 2006, it went for recording from the closer, then it went to Indy Mac Bank, FSBC.
The note.
The note. And it was endorsed over to Indy Mac FSBC Bank, FSBC. And then they endorsed it in blank and forwarded it to Deutsche Bank as custodian for HSBC. The reason it's Deutsche Bank is if you look at the actual trust, it is trustee for Deutsche Bank, alternate ALTA, and that's why it's in Deutsche Bank as custodian. The note was held continuously in 2007. I think the affidavit stated in 2007, January 8, 2007, the note was with Deutsche Bank as custodian for HSBC, and was continuously held there until there was a new servicer in 2014, and then it was transferred to Aquan, who is the current servicer through PHA.
This is the note. When does Indy Mac come in on the note?
Indy Mac was, I don't know if we all remember, but Indy Mac was one of the big mortgage servicers that failed in 2008. They take the note from these small loan originators such as Quicken Bank. They will then process it, make sure that it's filed, it's transferred to them, and then they transfer it when it's securitized to one of these trusts. They always do that in blank because it may be later negotiated to another trust.
What time frame? When did Indy Mac have this note transferred to?
Indy Mac had the note and signed it and transferred it over after it was received from Quicken, prior to it being sent to Deutsche Bank for HSBC on January 8th.
Appellant makes an argument that Indy Mac as a server can't be a holder of the note. What is your view of their argument that Indy Mac as a server cannot be a holder of the note?
Well, the whole server can't be a holder of the note. It's kind of a red herring. One, I don't think the case law says that. By any stretch of the imagination, Anderson does not stand for that proposition. But number two is the actual note was transferred to Indy Mac FSB. It's a bank, federally insured bank. The mortgage servicer was Indy Mac's subsidiary, Indy Mac Mortgage Servicing, which I think we clearly label in our affidavit. There's a servicing company, and there is the bank that negotiated the note. They are not one and the same. So as far as there being some issue with a servicer didn't negotiate this loan, this note. At any point, they did service the mortgage, and they continued to service the mortgage when it was with HSBC. And as part of that, they signed a loan modification in 2010. They signed another loan modification in, I believe it was 2013. And that's just something they would stand to do with power of attorneys that they have, which I believe we provided the power of attorney for PHH and Auckland in our affidavit. Shows that, and there would be a similar one with, with prior mortgage services, although I will say it was brought up by appellant that the 2010 note that was bought through discovery did not have the assignments on it. And their allegation is that these assignments must not have been until after 2010. I'll have you direct you to the document number 111, which is the filing of that discovery information. We go to page 134. You will see the request for document was, please provide a copy of the note from the day that it was signed by Mr. Brinson. We provided a copy of the note that was signed the day Mr. Brinson signed it. They did not sign the transfers the same day. Those were done shortly thereafter as it was transferred. We supplied what was requested, and we also stated that we could, the original note would be made available should appellant wish to see that at a time that we could agree upon. They never availed themselves of that. So there is no evidence that the note, did not have these assignments. That again is a red herring. That's not what the documents say. And the other issue was I believe that the appellant brought up was the mortgage assignments. Because I talked about the first mortgage assignment, which inadvertently said that the note was being transferred. The note had already been transferred. It was in continuous possession. We provided evidence to that. But the second assignment, it didn't change the name. If you look at the name, I think we described this in our affidavit. It specifically states in paragraphs 15 to 16 that the Deutsch, it says DALT on it, D-A-L-T. So what it did was there's an abbreviation for the Deutsch Alternate Security Incorporated, or the Deutsch Alt part, it's D-A-L-T. And all they did in the new assignment was that they put in the full name without the DALT, the DALT abbreviation. We spelled that out in the affidavit. So it is the same, it's the same trust. It's just the DALT versus expanding that out. And he's also, propellant also brought up, why do the endorsements on the note not match the endorsements on the mortgage? I think, or the transfers on the mortgage. I think we made that clear before. It's standard practice that MERS will hold some mortgage's nominee for whoever the signee is until a certain point at which is needed. And there's nothing that prevents that from happening. There's nothing in the statutes. In fact, I believe the trial court correctly pointed to the fact that even if it hadn't been transferred, as it was to HSBC the proper, we still would have carried equitable right in the mortgage by virtue of being the holder of the note. So there is no issue there. And I think it's clear that we've cured any deficiency that existed in the prior case in 2015 when the court sent this back. I think I discussed that there is no issue preclusion or re judicata based on dismissal without prejudice.
Can you point to what paragraphs in your affidavit that you filed with the most recent motion for summary judgment clarified what the difficulty were when the 2015 case was here before the Court of Appeals?
Yes, if you go to the affidavit, which is document number 107, and it's paragraphs 10 through 16, clarify the possession, the actual date that HSBC took possession through its custodian
Possession of the note.
of the note. Correct.
So you're saying, number one, you're the holder of the note. Are you also currently your client the holder of the mortgage as well?
They are. And it's in HSBC, that's also, that's part of that affidavit too. It's in 15, paragraphs 15 to 16. It has that issue. The other issue that was brought up, I'll try to get to that before I run out of time, at the end was that this is not a complete decree because it misstates potentially balances by two of the lien holders. I believe this was originally appealed previously and sent back because it didn't have the Ohio Department as a lien holder, the Ohio Department of Taxation as a lien holder. The court then corrected that with this judgment by adding them in. And I believe somewhere in the interim, about the Brinsons paid off the ACRA tax that was owed. And there may be there were some amended answers that were attempted to be filed to do that. I don't believe that they ever got approval from the trial court to amend their answer. And the trial court lists all of those amendments, et cetera, and dismisses them, enters the judgment with the amounts. It sets forth all those that have a lien, all the priority of the liens, and the amounts of the liens. I believe there is case law that says if those, when there was a Brzezowski case, that if there's some change, that can be taken care of when the confirmation of sale takes place. If there's some ministerial, if there's interest added, if somebody, for instance, go and make a payment on some tax, if they were to go and pay off their debt to the U.S., that would suddenly make that order invalid after the fact. That can be handled when the confirmation takes place and they divvy out where the money should go based on that priority that's been set.
And counsel, fortunately, I need to advise you that you have utilized your 15 minutes of presentation.
Thank you.
Thank you. I will try to be quick, although to my mind that this case keeps evolving. I heard some explanations here from opposing counsel that aren't really in the trial court record. I'll start off with that he mentioned, for instance, that what was IndyMac's bank role? He seems to say here that actually IndyMac Bank FSB owned this loan at one point and therefore could endorse it. It's not what they said in the trial court. They said it was a mere servicer. I don't know what its role was. I don't think you'll be able to go through the record and really nail that down. He seems to be saying now that these things go into MERS and they bounce around and they bounce around, and then when the game of musical chairs ends, they go out and try to create a chain of title that makes sense, and maybe they don't get it right sometimes. I don't know. It's everything in the record says it was a service. Now, I've also in the trial court, they didn't make this argument that the request for production asked for only the note as it existed at the time that Brinson signed it, and therefore they went back and found an old copy and didn't copy the one they had in their office. I don't believe that. For one thing, I don't think I have it in this record. I did put a lot of the documents in the record from that case, but the note on the complaint doesn't have that endorsement on it. The endorsements weren't there. And I would also say that the issue on res judicata, we found at least one case where standing, it was considered collaterally estopped from relitigating standing. This is the exact same effort. This is a mulligan. How many mulligans do you get? If they get reversed here, does my client have to live through another couple years of litigation while they take another try with a different affidavit? because, and quite frankly, I heard some different explanations here today. I understand that generally, when one dismisses somebody for lack of standing, they do it without prejudice, because somebody probably has standing. Or they can get a corrective thing, they can go back to Quicken, they can go back to whoever took over IndyMac and fix their chain of title and come back. They didn't do that, they decided to just try to explain issues away. The exact same, it's just relitigating the same case, the exact same case. Judicial economy says that if nothing changes, you ought to get the same result. And if they get reversed again, which they have to be.
So they indicate, Mr. Skinner, that paragraph 10 through 16 are where the changes are in the affidavit of the new case. Do you agree there are changes in paragraph 10 through 16, or is that just more restating what they said in the first case?
Yeah, I believe it's just restating what they said. I can't claim to have photographic memory of that MSJ affidavit. It was like 30 pages. But I don't, that is not my recollection of what it says. And also, you're going to have to reverse it. They have to, in terms of the last assignment of error, there was an IRS lien for $32,000 on the decree. They filed an amended answer, said, you know, we made a mistake, we're only owed 16. The decree's supposed to say the priority and extent of the liens. They're not right, they concede they're not right. This isn't interest accruing. It's no different than this court dismissing it for not being a final order when it said, well, you didn't tell us what the state of Ohio did. And by the way, the city loan is wrong as well, and they filed an amended answer. So my client shouldn't have to be behind lien holders that no longer have claims. The thing has to go back at least to be fixed for that. But I would ask that we don't do that and redo all this and then come back again, because they really haven't proven standing. And it always ends up the same thing. They say, this is our standard practice in the industry. It doesn't change Ohio law. Ohio law says you've got to have a chain of title that makes sense. And
Counsel, I need to let you know, you've utilized your 15 minutes.
thank you for your time and attention.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision in due course.